I've asked my man to take drop. No, look at camera now. Two camera will work for you. Can just copy. Copy.
Now, you can stand at that point for a few minutes, then we'll record you. Okay, but yes.
My brother, this is the issue of heart. Yes. No, like this. Somebody was...
This suit basically is against INEC, the Independent National Electoral Commission. Now, my client here was a candidate, was a gubernatorial candidate of the Labour Party in the just concluded election. Election concluded recently. I think that election took place on the 18th day of March, 2023. So he participated and he emerged the gubernatorial candidate of the Labour Party. And as a matter of fact, his name was initially published by INEC. While he was campaigning, doing all that it requires to secure his victory at the general election, he saw that his name was supplanted with entirely a different person. On noticing that, he wrote to INEC. INEC could not advance any reason for the unlawful substitution of his name. And consequently, my client ran to the Federal High Court. And of course, as you all know, the court is the last hope of the common man. On getting to the Federal High Court declared that yes, he duly emerged as a candidate of the Labour Party and that the INEC should publish his name because he's the authentic candidate of the Labour Party in that state. INEC refused. Instead of complying with that order, INEC and the then national chairman of the party, they appealed against that judgment to the Court of Appeal. On getting to the Court of Appeal, they suffered an ignominious defeat, where the Court of Appeal completely decimated and deprecated the residue of what was left of their case. And as a result, our client, again, was also further affirmed as the authentic candidate, gubernatorial candidate of the party. Now, further dissatisfied, they approached the Supreme Court. And the Supreme Court also dismissed their appeal against our client's victory. And INEC was further ordered or directed to comply with the judgment of the Federal High Court and publish our client's name. But as they would have it for reasons best known to them, they refused to comply with all this order. And indeed, the election took place. All this event we have chronicled took place before the election. Now, on the election day, my client could not now participate because, as INEC had a different name, even in the Formiciate E, that showed the declaration of the result, he was not the one. It was a different person that was there. Now the election has come and gone. Will the law now fold his hand and allow our client who has expended so much resources to participate, obtain the nomination form, secure the confidence of the members of the party who voted him, who nominated him as their candidate, and to further now participate or campaign in the general election? He's expended a lot of money to move from Federal High Court to the Court of Appeal to the Supreme Court. The principle is, will be juicy, be remedial. The question is, does my client have a right here? Yes. If he has a right, is there a remedy? Yes, there's a remedy. So he cannot now be allowed to fold his hand and go empty-handed. He cannot now be asked to be declared, he cannot now ask to be declared the governorship candidate of Labour Party in Ebonyi State because the election has since come and gone. Our client verily believed that if he had participated in that election, he would have won that election. So the election has come and gone. His only remedy is against INEC, who acted in impunity and in flagrant disregard and violation of the judgment of the Federal High Court, Court of Appeal, and the Supreme Court. The court will not close his eyes and allow an institution like INEC to treat the order of the court, the judgment of the court, in utmost discontent. No, the law will not fold his hand over that. So this man cannot be allowed to walk away without remedy. So he has now come against INEC to seek remedy in law. that remedy is very simple. It's saying now that you stop me from participating in that election against the judgment of the Federal Court of Appeal and the Supreme Court. So you are not liable to me in damages. And this being the first of its kind, I think we have positioned our law properly, and we position INEC to have respect for the institution that has been created by law. As you understand, the order of the court are not made for the sake of making. They are meant to be obeyed. When the court make an order or a judgment is declared, it must be obeyed by all parties. INEC owe it a duty. And there were parties in all those cases that moved from the Federal Court to the Supreme Court. You know, the sad part of it is that after the election, my client applied for a certified true copy of the list of candidates for Ebonyi State. And his name was not there. They certified it. So, meaning it was a deliberate, calculated, orchestrated attempt by INEC.
So what the remedy you said damages.
Yes. Our client is seeking damages in monetary compensation in the form of 50 billion naira against INEC. 50 billion naira, that is what our client is seeking. You know, ordinarily, I even told you 50 billion is too small compared to the humongous and colossal havoc that INEC have wreaked. That amount is even too small. But as we have it, we want the court to look at the matter head on, because we believe that our client have a right. It shouldn't always be that, oh, this has not been done before. We know that there are not too many cases along this line. But like Donny said, Lord Denny of blessed memory, once said, and I agree with his deposition, he said, what is the argument on the other side? That there is no case in which it has been done before. He said, but if the court never do anything which has never been done before, he said, then the society will move forward. The law will remain in one place and it will be bad for both sides. This is the first time. The court will be called upon because this will help stem the tide of impunity in most of our institutions in this country. We don't have strong institutions.
Are you of the opinion that the court will do justice to this demand?
I verily believe that the court will do justice to it.
On the final note,
Yes, sir.
what did the court say?
No, the court said, as you can see, today was the first time the matter came up before this court. And the court confirmed if all the parties have been served. And we said, yes, they have all been served. So, by the rules of court, they are entitled to 30 days to file their responses. So, consequently, the matter was adjourned. The matter has now been formally adjourned for hearing. So, on the next day, the matter is slated for hearing. And we believe that on that day, before that time, the parties would have filed their responses, and we would have also had the opportunity to file our reply to whatever it is their response is. The date is the 23rd day of November. That's the return date.
Based on the crisis in the Labour Party.
Yes.
So which notice?
No, I don't. I'm not aware of any crisis in the party. But what I understand is that Labour Party has been served. I'm not in a position. The case presently has nothing to do with the crisis in the party. And as a matter of fact, I'm not aware of any crisis in the party. So. Yes.
Will you and your client be open to a form of out-of-court settlement if the respondents now, if they make it?
Well, I do not want to. I've not discussed that with my client, and I do not want. And INEC themselves have not made such offer. So I do not want to preempt what my client will say. But when we get to the breach, we will cross it. Thank you. Anderson Asemota.
Gentlemen of the press, my name is Eze Oko Splendour. By the grace of God, good morning, gentlemen of the press. My name is Oko Eze Splendour. By the grace of God, I am the governorship candidate of Labour Party in Ebonyi State. This matter started when around 9th of June 2022, when primary election for Labour Party was conducted in Ebonyi State, and I was validly nominated as the governorship candidate of Labour Party in Ebonyi State. The primary was monitored by INEC, and subsequently my name was published by INEC as the governorship candidate of Labour Party in Ebonyi State. To my greatest surprise, when the second and final publication was to be made, the INEC went ahead to publish another name. But before then, I had already gotten the clue of what their manipulation and conspiracy was all about in INEC. So I quickly notified INEC that I have not withdrawn from the race, that I am still in the race. So when INEC didn't do anything as regards to the letter my lawyer wrote to them, INEC and the Labour Party connived to have a date for substitution primary without considering the fact that I have not withdrawn. Because the law is, before you conduct any substitution primary, the candidate must first of all write a withdrawal letter, personally deliver the withdrawal letter to the party, who will in turn deliver the same withdrawal letter to INEC. All of these things were not done. So when I saw the level of conspiracy, I approached the Federal High Court, Abakaliki. As God may have it, their substitution primary came on the 2nd of August. Then the court judgment came on the 3rd of August that nullified the primary they conducted and affirmed me the governorship candidate, because the judge there, Justice Rehman, was very explicit in his judgment. He ordered INEC to remove whatever name they have in their portal. And the name they have in their portal is Architect Edward Nkwegu Okereke. They ordered INEC to remove the name and put my name, Eze Oko, as the governorship candidate of Labour Party, because I have not withdrawn. They were not satisfied with that judgment. They had to appeal that judgment. So at the Court of Appeal Enugu, their suit was dismissed, affirming that I am the governorship candidate. They were still not satisfied with that judgment of the Court of Appeal Enugu. They went further to Supreme Court. To the glory of God, that's Labour Party. Labour Party. So as God may have it, I also defeated them in Supreme Court, which is the last court in Nigeria. And in all of these judgments that came, I instructed my lawyers to write to INEC, notifying INEC of the judgment in my favor. And that was done, sir. Here is the acknowledgement of all the judgment from the Federal High Court to the Supreme Court, and the notification to INEC that was duly served to INEC. So I was still not, because I was very, very inquisitive as at that time, so I had to come down to Abuja myself, went to INEC with the judgments that INEC acknowledged, met with a woman, they said is the HOD, legal department, named Mrs. Babalola. I met her with my colleagues. I told her that look at the position of the law, and the INEC has been duly served. So to my surprise, she said that nobody can compel her to do whatever we want her to do. I said, we are not pushing you to do. We are simply saying you people should obey the judgment of the court, because INEC is a creation of the law. INEC is not above the law. Then the woman became very, very upset and all of that. So I didn't stop there. I went up to meet with the commissioner of the legal department. I met her. I brought out my documents, my judgments to her. She went through all the judgment and said, please, I should not be distracted by whatever is happening here. That I should go down to Ebonyi and continue my campaign, that I am the governorship candidate. If by the special grace of God, Labour Party wins in that state, that I will be the governor to be sworn in. So with that, I left. She promised that the needful was to be done. So I went and commenced my campaign, my rallies and all that. To my greatest surprise, INEC continued to allow that name, Architect Edward Okwegu, to remain in their portal. So with this, my people, my voters, my supporters were confused. How can you be campaigning that you are the candidate and INEC is showcasing a different name in their portal? This caused a lot of harm, a lot of damage to my political ambition. So with that, I said, okay, I am going to apply for the CTC. Immediately after the election on the 18th of March 2023, I went to INEC, applied for the CTC of the governorship candidates of the 18 political parties that participated in the 18th March governorship election in Ebonyi. To my greatest surprise, gentlemen of the press, the name which court had ordered to be removed in their portal was still there, which is a vagrant disobedience to the court order. So why I approach the court is for the court to do justice to all of these things, to look into the matter and also tell us if INEC is now greater than the judiciary, than the law of the land. That is what brought us here. To the glory of God, the matter commenced today, and in the wisdom of the judge, he has adjourned the matter for the 23rd of November for hearing. So we are here because we are law-abiding citizens. We don't want to take the laws into our hands. We want the law to do justice to this disobedience of court order. Thank you.
Thank you. Iragbe Anslem, the National Youth Leader of Labour Party. It's a commonplace phenomenon in Nigeria since last year, 2022, the crisis in the Labour Party. Of course, it stemmed from the illegality. That illegality has culminated in what you find today. So we had a situation where party leadership, then under Abure, had refused absolutely to obey legal processes. You've seen a case where people had won valid primaries as candidates and they were substituted illegally, where all manner of documents were forged and uploaded in the INEC portal, similar to what we have found again even recently. So Splendour Oko Eze's case has become a phenomenon when it comes to this kind of illegality. And as to how best the legal institutions in Nigeria can deal with the issues of political matters, criminal issues. So for the Labour Party, the party is complicit in this offense, like you are aware, because the two defendants here, INEC on the one hand, the Labour Party on the other hand. So, but for the party, like you are aware, it is the party that uploads information in the INEC portal. So, but INEC, the judgment that came was to the extent that INEC should obey court order to implement the decision to remove the illegal name or names that were there and the issues which they refused to comply with. So basically this is the position. So the party's position, like we said, the party is complicit in the offense. The party has been joined in this matter with INEC and damages are being demanded.
Now, sir, when you say the party, under which leadership?
Now the party under the leadership of Abure as at that time, because this matter took place in 2022, stroke early 2023. Like you are aware, Abure was restrained on the 5th of April 2023. And this is the same matter upon which Julius Abure and 3 other National Working Committee members were restrained. Umar Farouk Ibrahim, the then National Secretary, Abure, then National Chairman, Ojukwu Clement, then National Organizing Secretary, Oluchi Okpara, then National Treasurer. So this is the same matter. So obviously, I think there's justification right now, because to the point where it is now on record from the certified true copy that was obtained in July this year, 2023, from INEC, to show that all the judgments that were validly given by the courts, High Court, Appeal Court, Supreme Court, were not obeyed. So in that case of Abure's indictment, like you are aware, the Nigeria Police Force Criminal Investigation Department conducted the investigation on this matter, because the counsel of the candidate had to apply to obtain certified true copies of what was uploaded from the party secretariat to INEC portal. So it was those evidences that unveiled these issues to find out that a withdrawal letter was falsely written with fake signature. The FCT High Court affidavit were forged. The court seal, so many issues. So all these things are in evidence. And for those of you who are close to us and the world, we have given that document, Compendium 57. There it contained all the forged documents as regards this matter. So, but finally, the candidate himself now, who is the authentic candidate, notwithstanding that the elections have come and gone, is now seeking redress. I think they ought to be redressed. And also, this should serve as a deterrent ultimately at the end of the processes, that when the court in Nigeria gives order, I mean, there should be implementation. And again, going further from here, we are going to the Inspector General of Police even right now as part of this matter to continue some of the processes we have instituted against the leadership then, Abure and his cohort, for redress. So it's a matter that has come to the fore. And I hope particularly the fourth estate of the realm, the media, the press, we pray that you follow us along this line so that the world will know, so that we can begin to rewrite certain injustices that have been done. Comrade Iragbe Anslem is my name, the National Youth Leader of Labour Party.